Hi, Sergeant. This is Jose Melendez. I'm sorry it took so long to get back to you. I've been having trouble with my phone.
No, that's okay. How you doing today, Miss Melendez?
Well, we're under duress, actually. This has weighed heavily on us. My girlfriend loses her job. We'll probably both lose our jobs and our houses unless some sort of due process applies here.
Okay, well, I'll tell you what. Take me through what you got going on.
You have a half an hour, you're saying?
Yeah,
Really? Okay.
all the time you need.
Well, you sound suspicious, but okay.
No. I'm in the office today, so I don't have I genuinely mean that. I got all the time you need
Okay.
to listen to your concerns or
All
what
right.
you got going on.
I've said this about 40 times in the last many weeks, so I'll try to parse and efficiently explain what happened. 2 days after I held my father on his deathbed, I got pulled over in one of the speed traps uh, where I wasn't speeding. Corporal Mann, who pulled us over, falsely accused us of not signaling. I explained to him at the roadside, that the car we had borrowed uh, dings if you cross the line without signaling. Are you familiar with such technology?
Yeah.
Okay, good. Now I've had one person say, no, it dings if there's a car there, but that also happens, but it's a different kind of ding. Do you know what I mean?
Right.
Okay, good. So we explained that to Corporal Mann, and Corporal Mann persisted and decided to tell Trooper Mall that I had unlawfully changed lanes without signaling. He then told Captain Lodholt of Yemassee the same story. These are both, by the way, this is my official report alleging that Holly Hill, South Carolina Police Corporal Mann apparently lied to two and possibly more law enforcement officers, Laura Ann Mall, and I'm forgetting Captain Lodholt's first name. Now, in the process, my girlfriend was trying to record because, well, sir, we watch the news, and I'm brown, and she's white, so as a mixed-race couple, we are aware that some people aren't liking that. My stepmother in the 60s had a gun held to her head for the same reason, and I was told that as a very young child, so that kind of stuck in my head. Anyhow, Captain Lodholt, when asked why this was happening, my girlfriend asked Captain Lodholt why they were placing the evidence that they were removing from the car after we said no to the search and asked for a phone call. I asked for a phone call to my attorney. My girlfriend asked for her Miranda rights or something, as Captain Lodholt was frustrated with her question. Her question, I believe, was, why are you putting the evidence on the car out here by the roadside? Are you doing this to shame us? On the recording, she is not being belligerent. I would like it if you or your agency would provide us with Trooper Mall's version of the events recording, because officers of Yemassee Municipal Court have persistently refused to disclose the the Rule 5 evidence that we duly and promptly filed for on the next day, July 17. We took a picture and video of Clerk of Court Billy Sanford receiving this Rule 5 evidence, and on that video you can hear our concerns expressed to Clerk of Court Sanford, to wit, that the first Google results that responsive to Judge McKinney and Yemisi were that Judge McKinney had stolen $5,000 from the Victims Assistance Fund in Varnville, hand of one with her sister, then the clerk of Varnville. When I raise this issue, generally people say, well, they don't understand why I would want to rehash that. And when I pointed out to at least one law enforcement officer that had I had such priors, it certainly would be addressed immediately. Regardless, SLED, the official report in R.E. McKinney, SLED's report says that the respondent, in this case Judge McKinney, received, endorsed, cashed, but did not deposit to her personal account $5,000 from the Victims Assistance Fund, but that there was no evidence she had ever possessed the checks. I'd like to pause here, and I'd like you to think about that for a moment, because this issue is about possession. This issue that we got arrested, that my girlfriend got arrested for, was really about her expressing her First Amendment rights, non-belligerently, attempting to lawfully defend herself and me. We did signal, as the Rule 5 evidence, that we were able to practically pry from Yemisi Municipal Court. They attempted to deny us access to that Rule 5 evidence that they promised us. The only thing we've gotten in writing from Yemisi Municipal Court, no receipts, no date and time we were to return, no documentation that I had been there, no receipt of what was contained in the Rule 5 evidence, which was just one of the 4 videos we had requested on July 17. Regardless, in open court before microphones, if I can get the recording of that hearing that they promised us that day, you will hear Corporal Strauss claiming that he could not release the Rule 5 evidence he had previously promised to mail us so that we would be ready for this hearing, because Chief Gregory Alexander had it under lock and key and was unavailable. Fortunately for us, and I believe you've probably read my email, no?
No, I just received an email from dispatch saying that you were trying to get in touch.
Okay. May I, while we talk, may I have your email address so that you will have received this?
Yes, it's Justin, Justin.
That's my kid brother's name, Justin.
Oh, yeah?
Yeah.
It's Rogers, Rogers.
And is there a dot?
Yep, it's Justin Rogers at.
Okay. All one word, Justin Rogers, with no dot in between.
No dot. At SCDPS.
Sierra, Charlie, Delta, Papa, Sierra.
That's correct. .gov.
G-O-V. Okay, while we're talking, I'm going to press send, and in a few moments you should be able to receive the affidavit that I sent to the Hampton County Sheriff, who is probably going to be calling me back this morning, and take my written report. This will be my second report alleging these issues. I previously called and spoke to the very kind and professional Corporal Christina Hernandez, who referred me to Deputy Director of the South Carolina Courts Administration, Robert McCurdy, who about popped. Do you know what I mean when I say popped? He was very frustrated to hear that Judge McKinney said that we would not be assigned a public defender because they didn't do that in the lower courts. He got off the phone and called me back some minutes later and told me that they now understood that they had to do so. And when I was finally able to reach Clerk of Court Billy Sanford again, By the way, 90% of my calls go unanswered there. It goes to something called MyTel. It rings and rings and then goes to MyTel. There's no voicemail often. But I figured out that they've got some sort of a caller ID, and they ignore my calls, because one of the last times I called, somebody else picked it up, and in the background you can hear them say, "No, it's Jose," and they hang up. I'm not sure how to address such issues. I don't see how that in any way represents due process. Regardless, fortunately for us, as Corporal Strauss on August 6th in open court claimed that Gregory Alexander was not there and had our Rule 5 evidence under lock and key, Chief Alexander interrupted those proceedings in an excited utterance. He bellowed at my girlfriend, who has PTS. I had the floor, so Elizabeth Wallace left the room. As she walked out of the room, because she didn't have her reading glasses on, and this will be important later, she squinted and saw Chief Alexander's name tag. I almost said badge, but I believe it's name tag. And she said, "Oh, Alexander, you're the chief, right?" And he said loud enough for everyone in the courtroom to hear the following: "You know who I am. You did your homework." Well, you may remember that I mentioned that we expressed concerns to Clerk of Court Billy Sanford, who dismissed those concerns and said there would be no bad apples, and that he didn't have any knowledge of such improprieties as we raised about the judge. And now we found out that Chief Gregory Alexander was charged by a grand jury with stealing over $10,000, but let off by a jury of his peers. His chief at the time in Yemassee claimed to the local news that it was unknown who stole that $10,000. Now that chief shouted at my girlfriend and threatened her, and the reason I know that "you know who I am" to a witness of federal and state crimes is a threat rather. The reason I know that is we can't afford a lawyer, but I am a data scientist. So I downloaded legal research software, and when I typed in quotes, the phrase "you know who I am," and I forget the other term, I'll write it down and email it to you, several hundred cases popped up where many people were charged for threatening witnesses using that exact phrase on the grounds that they said, "You know who I am." So anyhow, we left Yemassee Municipal Court with the Rule 5 evidence, because now that Gregory Alexander had made his appearance, they couldn't deny he was there. When I pressed Corporal Strauss on the fact that he was not the arresting officer, that Captain Lodeholt, as I described, and was, Corporal Strauss demurred. Do you know what I mean by that word? Mm-hmm. Okay. I'm sorry, I don't mean to be patronizing or argumentative, but this is a very difficult thing, because, again, she's going to lose her job and her license to teach in the state of Florida, and I probably already will lose my contract as Chief Technology Officer for Skydive University. Now that doesn't pay very much. It's $300 a month. So as you might imagine, I'm living hand to mouth. But regardless, I have been doing my due diligence for many weeks now and looked at the laws and case law and precedent and legal responsibilities of officers of the court, including public attorneys and other attorneys. And what I'm finding is that extrinsic fraud is defined as officers of the court perpetrating fraud upon the court in conjunction with an attorney. An attorney called us when we tried to get a public defender. His name is Ian Dasak. When he called us, he advertised the legal term for advertised, according to the law, is disclosed or warned. He advertised that he was quitting soon and that he could probably take care of this case for $1,200 to $1,500. When Elizabeth explained that Yemassee Municipal Court had already stolen all of our money, including her last month's mortgage payment, which she was just about to be able to refinance the home, and she had already been living close to hand to mouth herself. So this is a major financial stressor to her. When she explained to Attorney Daysack, I think it's Dysack, that Yemassee Municipal Court had stolen all of our money, he, knowing that he was being recorded, he said that he advised that we should beg Judge McKinney, and then he said it again, he emphasized beg Judge McKinney on due process grounds, because as I explained to you earlier, they are not going to assign me to your case. They are, in my opinion, not following the law in this regard. So you should beg Justice McKinney on those grounds, and it should be dismissed. When we did so on August 6th, before Judge McKinney, amazingly, the Honorable Judge McKinney agreed and concurred with Mr. Daysack's opinion and stated, I think the term is sua sponte, she volunteered that they were not assigning public attorneys in the lower courts. We have been unable to get anything in writing, as I mentioned, at all from Yemassee, not even the date and time we are to appear. When Deputy Director of the South Carolina Courts Administration, Robert McCurdy, read them the Riot Act, I was able to get Clerk of Court Billy Sanford to disclose very reluctantly. He said he couldn't talk to me because our attorney would call us. He did not call us. He emailed me and asked me to call him. Regardless, I was able to say, Billy Sanford, you are the clerk of court. Please tell me the date and time that we are to appear. And he said reluctantly that it would be at 3 p.m. on the 19th of this month. We don't have enough time, even if they were to mail overnight the videos today, to review them, but we are going to show up in court. Now, Ian Daysack called us up later after our court hearing and said that he was probably not going to be in any trouble, a slap on the wrist I think he mentioned, for making the statements that he said we should say to Judge McKinney, but that I apparently knew just enough law that Judge McKinney on a whim may put me in jail for 6 months for contempt of court. Now, I do have recordings of Judge McKinney, Corporal Strauss, and and Chief Alexander stating the things I say. I would prefer that Yemassee Municipal Court, as they said in open court, released the videos from the police cars, the audio from those cars, the audio from the radio traffic, and the audio and any video from both Elizabeth Wallace's hearing before Judge McKinney and the hearing that I'm describing on August 6th. They did say, Corporal Strauss and Judge McKinney said, we would have those in 10 days. It has been far longer than 10 days. Calendar days, business days, unless it's some sort of Aztec days, it's been longer than 10 days. And they have not sent us anything or responded in writing to anything. I have sent carefully worded affidavits, making sure that they would pass muster. In other words, that if I said them under oath and swore them into evidence, that I could not be charged with perjury unless I made some typographical or innocent error. I have...
Well, let me
Go
ask
ahead,
you,
yes, please.
Mr. Melendez. So basically, and what I'm gathering, you got a lot going on here. I can see that it looks like, obviously this stems from a simple possession charge.
It stems from an unlawful stop at mile marker 37 on July 16 by Corporal Mann, and that has been apparently confirmed by his superior, Chief Josh Detter, who took my report, stating that Corporal Mann unlawfully pulled us over. Now, I have a recording, and I believe in the email that I sent to you, there's a link to the recording of me making that report to Chief Detter, who claims he will be at 3 p.m. in Yemassee Municipal Court as a witness.
All right. Now, as far as I understand that Yemassee, it looks like Yemassee, this Corporal Strauss he actually issued the uniform traffic summons there.
He admitted. I'm sorry, I didn't mean to interrupt you. Go ahead. You go ahead and say it again, please.
No, is it the Corporal Strauss? Is that who issued the ticket to you?
Well, let me
ask you this. This is I'm a sergeant with a highway patrol. Okay, I don't have anything as far as involvement with Yemassee PD. Really, my major concern is as far as if I have troopers out there, and there's a complaint against a trooper.
Well, the statement that I'm making as a report of criminal activity is that Corporal Mann lied to your trooper, and that Corporal Strauss, hand of one with Captain Lodeholt and Chief Alexander and Clerk of Court Sanford, have apparently committed felony suppression of exculpatory evidence. Now, you asked if Strauss issued the tickets. The ticket is inscribed with an incorrect, a fraudulent, or maybe a non-existent is a better term to use, statute. If you look at the email I just sent you, I'm hoping that I sent you a picture. Can you see the attachments? Okay. If you look closely, you will see that it does not match any known statute in South Carolina. The statute in South Carolina for simple possession is 44-53-370, parentheses, lowercase d, parentheses, 4. The ticket is inscribed 44-53-0370, parentheses, capital D, parentheses, 4. Now, as a data scientist, I am willing to acknowledge that a leading zero can be ignored. However, there is no capital D in the actual statute, and the statute as printed on the ticket is non-existent. In addition, Corporal Strauss, when pressed before the microphones in open court before Judge McKinney, I don't know that he was under oath because he wasn't sworn in by Judge McKinney in our case, but he had been sworn in a previous case just before, so I'm guessing he still has to tell the truth. Corporal Strauss hung his head when asked if he had arrested, if Captain Lodeholt had arrested Elizabeth and not him, as it says on the ticket. Then, when pressed again, he said correct, that he had not arrested Elizabeth, that Captain Lodeholt did. So Elizabeth was unable to face her accusers. We were denied our Rule 5 evidence. We are still being denied our Rule 5 evidence. You have Trooper Mall's video, and I'm filing this report to you.
Okay. So basically, you've done a Rule 5 request.
Yes. No, I've done. I'm sorry. Say again, please.
You've done your Rule 5 request through the issuing
Yes,
part.
at Yemassee Municipal Court, I pulled out a camera and asked that I be allowed to take a picture of Billy Sanford stamping the document. I am a photo finisher by trade since the early 1980s and a photographer since I was 4 years old. I took very crystal clear pictures that are practically document quality of him receiving the Rule 5 request, a close-up of that Rule 5 request, and was running video at the same time as he claimed things that we now know to be false.
Okay. Well, basically, what happens is this. Seeing that Lance Corporal Mall was not there again until I speak with her, I don't know.
She was told, but she was told that she would not be allowed to search the car, and Lance Trooper, you say, Mall?
Lance Corporal Mall?
Lance Corporal, I thought it was Trooper, I'm sorry.
It's Trooper, but her rank is a Lance Corporal.
Thank you kindly, I appreciate the correction. Mall told Elizabeth that she was not allowed to videotape as she conducted this search. Elizabeth said, well, you're a public official in the conducting your official duties in a public place. And Mall claimed that it was for her safety that Elizabeth must not record. Elizabeth protested non-belligerently, as you will hear if you watch and listen to her video.
Mr. Melendez, can you hold on 1 second?
I can.
Thank you. Okay, Mr. Melendez, I'm sorry about that.
You're fine.
Another call.
Okay, so yes, we have a complaint against Lance Corporal
Mall.
Laura Ann Mall. Now, they laughed at me when I explained that my father had just died. Corporal Mann, when I told him that my father died, said, okay. And then minutes later, he can be heard in the recording that we were able to get from Yemassee Municipal Court. Minutes later, Corporal Mann of Holly Hill said, oh, and by the way, I'm sorry for your loss. Now, I get that law enforcement officers are allowed to lie to the public, to civilians, if you will. But my report is that the Rule 5 evidence that we have so far discloses that Corporal Mann apparently lied to Trooper Mall and lied to Captain Lodeholt, and when we get the other videos, I believe it will be shown that he lied to Corporal Strauss. Also, if we get the video from Corporal Strauss's and Captain Lodeholt's cameras, you may see that Corporal Mann attempted to distribute something out of the back of his vehicle. He asked a couple of officers if they wanted some of this. Now, we believe that if it was us saying that on recording, that police officers would have said that we were trying to sell the marijuana that apparently they decided to charge us with. However, I have raised in my affidavits my dispute of the facts in this case, not least of which because in response to my Freedom of Information Act request, the South Carolina Department of Health and Environmental Concerns conceded that marijuana does, contrary to statute 4453180 and 190, they confirmed that marijuana does have accepted medical use in the United States. In fact, that agency was required to produce a report and make findings as to the states in the United States that had medical marijuana laws and how that affected the use of opiates in addition to veterans issues. Excuse me, I've got some coffee grounds in my mouth because I don't have enough money for a coffee filter right now. So when I received that Freedom of Information Act request, I added another affidavit to the Yemassee Municipal Court and emailed it to them. They have never responded to any of these emails, but regardless, it is true that marijuana has accepted medical use in the United States, contrary to as falsely mandated in 4453180 and 190. So there is a genuine dispute of the facts in that case, and we are asking for a jury trial, and we are asking for our Rule 5 evidence, and we are filing reports that these officers of the court, in conjunction with either Attorney Dasak or the Attorney Geyer, who previously claimed he could not represent both of us, but then when his now apparently regular employer, Yemassee Municipal Court, assigned him our case, he now said that he could represent both of us. I immediately wrote him a letter pressing him on these issues, and when he did not respond to me, I called his office. His staff listened to these same issues that I was raising and made it clear that they were acting on behalf of their client, Yemassee Municipal Court, and said that when Geyer told me that he could not represent both of us, something he offered to do for one of us for $5,000. I believe his quote was $5,000. This is for a $200 ticket, maximum by the state of South Carolina. The maximum fine is supposed to be $200. Now, Yemassee Municipal Court was gigged. Do you know what I mean by the word gigged?
Mm-hmm.
Okay, by the state auditor, Kennedy. I can't remember his full name right this moment, but State Auditor Kennedy in 2017 did an audit of Yemassee Municipal Court, as they must have every year. We have a copy of that audit and the next year's audit. In the 2017 audit, he says that they were incorrectly charging people. The bond side road amounts were higher than the maximum allowed by law, and the judge did not correct them, and that he recommended that the officers be retrained to follow the law. So Misty Reardon, at the time, the clerk of court at the time of Yemassee, wrote a short, almost terse letter in response, saying that it was just an oversight, that they had some new people and they were retraining people. Now, those charges are more than triple the maximum fine, and even Deputy Director McCurdy could not explain what law allows that to be possible. Christopher Geyer hung up on me when I asked him about that issue when he was not the public defender, but then some days later when he was assigned our case and he responded to my email. He never did call me, as I was told by the clerk of court, by the way. He also never contacted Elizabeth until she protested that there still was no public defender at all in our case, and certainly she had never been contacted. Now I can send you all of this documentation. But
no, it's okay. I mean, so as far as are you really what I'm as far as Trooper Mall, because there's nothing as far as the systematic
Trooper Mall did
judicial process and everything else.
Yeah, but Trooper Mall did search the car after we were falsely pulled over and told that we were not agreeing to the search, and also told Elizabeth that she must not record or document that search. I'm asking that you take that report now.
All right. So basically, what we've got falsely was a dog a canine presented to the exterior of the car.
No, there was no. They haven't.
No canine.
I'm sorry. What?
No canine was on scene.
There was a Trooper Mall's vehicle was marked canine, as I believe. However, she either had a very small dog or did not bring it out.
Okay. And let's see. Said she.
Now they claimed that they had caught Elizabeth with an open container, and they said that with regard to the marijuana that they must charge us under hand of one. Could you tell me what that means? Hand of one? What's the rest of the phrase?
Basically, hand of one is, in South Carolina you have what is known as constructive possession.
Oh no, I believe I know what it means. I just mean for you to say out loud. Is it hand of one, and then what's the rest of that phrase?
Well, I really can't.
It's okay. It's hand of one, hand in all. So Trooper Mall, along with Corporal Mann and Captain Lodeholt, sniffed the container of what I believe to be coffee. It's possible there might have been some craft beer at the bottom of the cup. We had been driving all the way from Florida up and down, and we were done. We were tired, exhausted, and frightened when we left Yemassee Municipal Court because, as I mentioned, Chief Alexander threatened us. But regardless, Trooper Mall sniffed, I'm not sure how she calibrates her nose, but she sniffed the beer, what she said was beer, and handed it to Corporal Mann, who did the same thing, and offered it to Captain Lodeholt, who I believe declined. I believe you can see on the Rule 5 evidence that they have disclosed thus far, declined to smell it. Later, they destroyed that evidence by pouring it out on the ground in front of Corporal Strauss's car. I think it was Corporal Strauss's car. Now, in the audio that I linked, and I hope that I sent it to you, there's a YouTube audio of me making my report to Chief Josh Detter of Holly Hill, in which I explain that when I asked Captain Lodeholt about whether or not why Elizabeth had to be arrested and couldn't they just arrest me instead, he said that the reason, I'm paraphrasing here because it's been a long time since I watched since I was there on the scene, and they won't release this audio to me yet. But he said, to the best of my recollection, that the reason Elizabeth was being arrested was that she was interfering with their business. Now, when I mentioned that to Chief Detter, as you will hear, he, you know what a tell is, like in poker?
Mm-hmm.
Yeah, well, when I said those words, that Captain Lodeholt explained that Elizabeth was being arrested because she was interfering with their business, Chief Detter harumphed. I will send you the link again if you don't see it. I'm going to look and see if I do a search for YOUTU, and ING. Yes, there's a link to that conversation just above my name. Do you see on the email where it says *//video and then https://YouTube? Do you see that?
I do.
Okay, good. If you will, click that link and listen to it maybe later. Or, you know what, I can click it right now. Would you like to?
No, it's okay.
Oh, you don't want to listen to it now?
I'll listen to it. I'll listen to it.
Okay. If you listen to that, you will hear that at the beginning of the conversation, Chief Detter is still relatively skeptical of my claims. At the end of the conversation, you can hear that he's frustrated with his... Are you something wrong? You still there?
Yeah, I'm here.
I thought I heard something. Okay.
There's radio traffic in the background, but it's okay.
Okay. So, well, now I believe I've lost my place, but you should be able to hear that, yes, Chief Detter is less skeptical and rather frustrated with the apparently unlawful conduct of his staff. He did say, now I'm just spitballing here, but it's possible that Corporal Mann did not see that you did signal. And I said, sure, except the video shows both angles. It shows my car signaling within the legal limits. I believe within any reasonable margin of error, it can be proven that I did signal 100 feet or just under 100 feet if I was driving 71 miles per hour before I changed lanes. I also signaled when he pulled me over and did the same thing. When I learned to drive, my parents told me that I must be a great driver because my mother fell asleep in the car. They were impressed with my driving. I learned to drive in Boston, which is a notoriously difficult place to learn to drive. And I'm 50-something years old and have had a motorcycle endorsement for probably, let's see, since 1994 or 93, maybe 92. I'll have to look. So I'm aware that I have to signal so that others may safely know that I'm about to change lanes and actually look before I change lanes. It's difficult to see if I looked because of the resolution of the video, but unless I doctored the video, there's no question but that I did signal. Now again, we would like you to provide to Yemassee Municipal Court, perhaps, Trooper Maul's recording and video if possible. If not, then we would like it to be preserved as evidence in this, for this report that I'm making.
Yeah, what I'll do is just kind of, let you know our course of action here. As far as any complaints that come in on any troopers, we're going to field them. We're going to talk with you first. We're going to see exactly what we're looking at as far as issues, policy violations, anything like that.
Will you be reviewing the video in that policy violation?
I will call her.
No, I'm asking, will you be reviewing the video from her camera angle that confirms what I'm saying? And if that video confirms what I'm saying, then what will happen to that video?
Well, basically the video is, and I'm going to say that this one here, traffic stop was July. I will go back and look at it. It will be preserved, yes.
Yes, but will it be presented in court to Yemassee or given to us as part of this?
If the Rule 5 has been, and that's what I'm going to have to check with her and see if she has talked to anybody from Yemassee.
I don't think that they asked for it. I think that they're trying to cover this up because I think that there is culpability that they figured out from the questions that I carefully asked at the roadside.
Well, and look, if that's the case, look, we've got. What I'm going to do is I'm going to call and I'm going to speak with her first.
Yes, sir.
All right, about this incident. I'm going to go ahead and try to retrieve the video. Go ahead and view the video. Now, I'm going to ask her as far as if it's been Rule 5 yet. And typically that's what's going to happen. Any charging document that is issued or a case case file preparation, that officer is going to come back if we have a secondary officer on scene, and they're going to say, hey, we need you to make a copy of that tape. You know, it's going before a jury trial, bench trial, whatever. So in that instance, she would make a copy of it and supply it to, in this case, Yemassee. If they have not, and we still have it, you're still okay, because you can contact basically our Freedom of Information Act department, and they will give you the steps as far as securing that footage back to you. Okay.
Can't I do that already without having to wait?
If they have Rule 5, if a Rule 5 has been served, then yes, it's already been moved over.
And
it's already been. If not, then you'll have to go through the and we'll get there. We might not even be dealing with that. If that's the case, then I will get you that department within South Carolina Department of Public Safety. They just have to have it on file. What that does is that secures everybody's rights and freedoms to footage, especially if you're involved. So we're not going to release any footage for somebody that's not involved.
Yes.
Jeopardize your case.
Understood.
So let me talk with Trooper Mall. I'm going to call her directly, and I'm going to get her to basically give me a synopsis of the events on this date, which was July the 16th.
Yes.
And I've got the time on this ticket here.
Yes.
She should be able to remember, and I'll pull that up, and we'll see if we can get some video on it. And once I get done with her, I will call you back.
Before you go, I'm sorry, I didn't mean to speak over you. My phone has a little delay on the line. You go ahead.
No, it's okay. But no, I will. As soon as I get done with that, I will call you back directly. And if it's been released over in a Rule 5, I will let you know that. If it has not, then we'll go on to the next steps.
Sergeant, before you go, may I say that in the Rule 5 evidence that we were provided with reluctantly, the video shows that Corporal Mann never patted me down when he put me in his car, and that he decided to get out of the car to do the search after I told him that I wanted a phone call, and Elizabeth said no. Do you believe that in that case that either one of those officers believed I was a danger to them, because I had access to his vehicle and he stood in front of it?
Yeah, I mean, to be honest, I really, as far as this case goes, Mr. Melendez, you know, our policies and procedures are going to be different than, I know as far as...
I get that. That Holly Hill might have...
Department of Public Safety versus Yemassee versus a county agency.
Sure.
They all differ.
Surely Lance Corporal Laura A. Mall will recall that I was still in the car when she was going through our personal belongings after we had told her no, that they could not search. And do you believe that, knowing that I was in control of his vehicle, that she believed that she was in any danger from me?
Listen, it wouldn't be fair for me to speak.
Okay. So if you saw that I was in the car, do you think that you would have thought that I was any danger to you as you were standing in front of that police car?
There again, Mr. Melendez.
Okay, fine. That would be hypothetical. I get it. Now, yeah. I can assure you that in the recording you will hear Lance Corporal Laura A. Mall claim that the reason Elizabeth was not allowed to document her conducting her official duties in public was that she was concerned, was that it was for her safety. Now, there is a disparity there. Would you agree?
As far as the safety issues, no, that's going to be, as far as a trooper asking as far as cell phones, it's unfortunate, but in the society we live in, and this is nothing against you or Elizabeth, the society we live in is somewhat of an unknown right now.
No, that's not what I'm saying. I'm saying she claimed in her official capacity as a trooper, that her safety was the reason behind Elizabeth being disallowed to document the unlawful search. However, I had control of the vehicle.
Right.
So she was not in any danger from either of us. There's no that claim is specious. Would you agree now that I phrased it?
All I will say is this: as far as our troopers, cell phones on the side of the road. No, we typically, as far as a safety concern, we don't want them out. We don't want you making phone calls. We don't. It has nothing to do with any cover-ups or anything like that.
So it's a safety issue to disallow the documentation of an official conducting her official duties in a public place, but not a safety issue that I'm in a car untied down.
I understand what your point you're trying to make.
Yes.
But you're going to have all this that you're presenting. You're going to have your day in court. It's obvious.
Apparently, I am at risk of getting arrested.
What we've got to get figured out right now, directly, is I just want to make sure that my trooper is in compliance with policies and procedures.
Okay, that's fair enough, and I won't waste your time. I hope that I have not offended you.
All right, and let me talk with her, and we'll get it situated, and I will call you back.
Will you promise me that you and she will
You have my word.
Wait. Will you promise me that you and she, perhaps together or separately, will review the video and audio of her camera?
Yes.
Thank you kindly.
Okay.
All right, sir. Thank you.
Thank you.